Good day to you and welcome to another Paddocks Club video tutorial. Today we're going to ask the question, when is the body corporate obliged to issue a levy clearance certificate? And the peripheral question is, are trustees under an obligation to issue a levy clearance certificate if all monies due by the seller have been paid or secured? What if the seller has other unfulfilled obligations? The context of this question comes from the discussion forum where we were having a discussion about a rule which would empower the body corporate to refuse to issue a levy clearance certificate until the purchaser has confirmed knowledge of the scheme's conduct rules. And in this particular case, we were talking about the pet rules because people were regularly moving in with pets saying, I've never heard of your rule that we couldn't have pets or we can only have one pet or whatever it happened to be. And the comment was made that whether the purchaser has signed any other document is irrelevant to the issue of the certificate. The members' view was if levies have been paid or provision has been made for that payment, then a certificate must be issued. I had a good look at the wording of section 15b3a 1aa. That's a bit of a comprehension test, that particular name, but the registrar, it says, must not register a transfer of a unit unless a conveyancer certificate has been lodged, and that certificate must confirm that, with effect from the date of registration, the body corporate has certified that all monies due by the transferor to the body corporate in respect of that unit have been paid or secured. Now, this is not an obligation on the body corporate to issue a clearance certificate. It is a restraint on the registrar's power to effect a registration of a sectional property until such a certificate has been given by the body corporate and certified to exist by the conveyancer. My view on the more general question is that whether or not the seller is in breach of any other obligation to the body corporate is relevant, very relevant. The body corporate is not obliged to allow the transferor to leave the community by transferring his or her unit if this means that it effectively loses its security for the performance of an obligation due by that transferor. The body corporate can make rules, I believe, requiring a reasonable assurance from the purchaser before a levy clearance certificate is issued. Thank you for joining me in this Paddocks Club tutorial, and if you have any further questions, we can deal with them in the discussion forum.